Hello, friends. Today, let's talk about constitutional amendment in India. Constitutional amendment is the process through which the constitution of any country can be amended or changed. Indian constitution under Article 368 says that it can be amended by the legislature by way of addition, variation, or repealing of any provisions of the constitution. Amendments are necessary because change is the only constant, and over a period of time, the society changes, social structure changes, and amendment of the constitutional provisions are necessary to keep the constitution contemporary. It also gives the citizens a say in the manner in which they would want to be governed. It also addresses certain unforeseeable situations that might arise which could not have been foreseen by the founders of the constitution. Under Indian constitution, there are two broad ways in which the constitution can be amended. One is by simple majority and number two via special majority. Let's have a quick look at simple majority. Simple majority means when out of all the members that are present in the house and voting for that constitutional amendment bill, more than 50% of them vote in favor of the amendment. That is, more than if we presume that 504, all the 545 members of Lok Sabha are present, then at least 273 votes are casted in favor of the bill in Lok Sabha. And if the Rajya Sabha is all the members are present, then 123 votes out of 245 are casted in favor of the bill. Now let's presume that out of 545 members, say 45 members are absent and 100 members are abstaining from voting. Then the current strength of the Lok Sabha at that time would be 400. And therefore, at least 201 votes would be needed for the bill to be passed in the Lok Sabha. And it is important to note here that only the members who are present in the House can vote for the bill. All the regular bills of parliament are passed through simple majority. Some constitutional amendments can also be passed by simple majority. For example, establishment of states, changing the names or boundaries of states, creation or abolition of a state's legislative council, that is the Vidhan Parishad, deciding the quorum of the parliament, which decides the minimum number of members that are needed for the parliament to function, or the bills which pertain to second schedule of the constitution that deals with allowances, privileges or emoluments for the president, the governor, judges, speakers, etc., or any change in the rules for acquisition and termination of citizenship, or rules under fourth schedule which relate to the allocation of seats in the Rajya Sabha. These are some of the scenarios where a constitutional amendment can be passed by a simple majority. Article 368 talks about special majority. Now, under Article 368, the Constitution states that the Parliament will have the power to amend it. It lays down the procedure very clearly. First is that the bill can be introduced either in the Lok Sabha or in the Rajya Sabha, and it can be introduced by any member of the House. The bill should be passed separately by Lok Sabha and separately by Rajya Sabha. There is no provision for a joint sitting of houses for voting purposes. Number 4 is the condition on the number of votes that are needed to pass the bill. This is the most critical part of it. Here there are twofold conditions. Number 1, the total number of votes which are casted in favor of the proposed constitutional amendment should be number 1, majority of the total strength of the House. That is, the votes that are casted in favor of the proposed amendment should be more than 50% of the total number of members in that House. So, in Rajya Sabha, it would be at least 123 votes out of 245 and at least 273 votes out of 545 in Lok Sabha. But it does not end here. There is another very important condition, that is, At least two-thirds of the total members who are present in the House and voting for the bill must vote in its favor. Let's understand this with clarity with the help of two examples. Let's take out of 545 members, 500 members were present in Lok Sabha for voting and 400 members voted in its favor. Now let's see whether the number of votes passes the criteria laid down in Article 368 or not. The first condition is that the total number of votes in favor should be more than at least 50% of the total strength of the House. Total strength of the House is 545. More than half would be at least 273 votes. The total number of votes in favor of the bill were 400. Now 400 is greater than 273. Therefore, the first condition is met. Now let's have a look at the second condition. Two-thirds of the members who are voting should vote in its favor. Total number of votes that were casted were 500. Two-thirds of 500 is 334. So at least a minimum of 334 votes were needed for the bill to be passed after meeting the second criteria. Now here 400 votes were casted in favor of the bill, which is much more than the minimum requirement of two-thirds of the vote, that is 334, and therefore the bill would be passed and sent to the President for assent. Let's take a different scenario. Let's presume that only 380 members were present in Lok Sabha, out of which 268 voted in favor of the bill. So, two-thirds of 380 would be 253. So here the total number of votes that were casted in favor of the bill were 268, which was more than the two-third requirement in Article 368. But there's the first condition as well, that is the total number of votes in favor of the bill should be greater than 273. Now 268 is less than 273. Therefore, the first condition is not met. The second condition is met. Therefore, the bill is not passed, and maybe they will need more to introduce the bill once again when they have more members in its favor and get it passed. Most of the fundamental rights can be amended through Article 368, but here the courts have held, as in the case of Nanda Bharti, that the basic structure of constitution should not change. So along with fundamental rights, the directive principles of state policy can also be changed through this process, or any other provision of the constitution which cannot be altered or amended either by a simple majority or by the proviso of Article 368. Then in all those cases, Article 368 will become active and will be used to make constitutional amendments. Now let's have a look at the second requirement under Article 368, that is by special majority and consent of states. If any amendment that is brought about by the Parliament affects the federal structure, then the amendment bill has to be passed by both the Houses of Parliament separately by special majority, and along with this, it must also be ratified by at least half of the state legislatures. That is, at least 14 out of 28 state legislatures should vote in favor of the bill. Once this minimum threshold is reached, the bill is considered passed and can be sent to the President for his or her assent. Examples of some of the cases in which the special majority rule along with the consent of state is needed is when any change is proposed in the process for the election of the president, or any proposal which has an effect or which changes the legislative and executive power of the states, any change in the number of seats through which the states are represented in the parliament, or if there is any change in the 7th schedule of the constitution which talks about the union list, the state list and the concurrent list. In fact, any change that has to be brought about in Article 368 also has to go through this process. Now, friends, apart from Article 368, there are two more very important articles in the Indian Constitution where a simple majority will not work, will not be relevant. Let's take Article 249. Article 249 empowers the Parliament to legislate on a matter in the state list, provided it is in national interest. Here it is needed that the resolution is passed by two-thirds of the majority of members who are present in the Parliament or in the houses and voting. Another case is the case of Article 61, which talks about the procedure for the impeachment of President. Here, the special majority that is needed is that two-thirds of the members of the total strength of the House, that is 364 in Lok Sabha and 164 in Rajya Sabha, must vote in its favor for the procedure to be implemented. So, friends, I hope this video made the distinction between simple and special majority that is required for the amendment of constitution clear to you. Here it is important to understand that in situations where the amendments could have had far-reaching implications, the founders placed a higher threshold on the majority and conditions that had to be fulfilled before the said amendments could be passed and inserted in the constitution. I hope this video was helpful in understanding the basics of constitutional amendments. Thank you so much for your time, and I'll see you soon with another video. Till then, goodbye and take care.